Good morning, everyone. Welcome to the Global South Symposium on SOGIE and ESCR rights, a reflection of evolving laws and jurisprudence in Africa. For those of you who don't know what SOGIE is, it's called sexual orientation, gender identity and expression, and economic, social, and cultural rights. Today, we're going to have an absolutely wonderful, wonderful, wonderful thing to do. And before we start, I just want to let you know that welcome to today, and it's going to be absolutely wonderful. We also know that interpretation for this webinar is available in French, so you can click on the interpretation icon on your Zoom control panel and select the language that you require. And I also wanted to say thank you for joining us, and we hope that you will have an absolutely wonderful time during this program. And now we want to take it over to Professor Frans Viljoen, who will welcome us from the Center for Human Rights at the University of Pretoria. Professor, over to you.
Thank you very much, Leklo Gonolo, and good morning from my side as well, here where we are. It could be a good day to play it safe. It is really a privilege for us at the Center for Human Rights, University of Pretoria, to partner up with the ICJ, and specifically the African Regional Program, International Commission of Jurists, to be part of this event. I think it has been carefully brought together, and as was indicated, there are really two focal points within our discussion. The one is socioeconomic rights, and the other is the rights of what we sometimes euphemistically call the rights of sexual and gender minorities. The center's interest in this is that, if I have to describe our mission, I often say that we try to advance the rights of the most marginalized, the often forgotten and sidelined groupings or communities, particularly in Africa. And among those, I think certainly those materially deprived, people living in poverty, are often kind of submerged into other thinking and groupings without getting the particular attention they deserve. And I think the idea of justiciable socioeconomic rights harks back to the overriding concern and I suppose the interest in how to breach these divides of inequality, how to cater better for the rights of those materially deprived, and how can the law play a part in that. So that's the one aspect of our symposium. The other aspect is then clearly the rights of those that are called sexual and gender minorities. In other words, the issue of equality, irrespective of one's sexual orientation, your gender identity and expression. The center has a unit on SOGIE, and we have a short course that we've been running for many years, focusing on socioeconomic rights. So these are things that we try to mainstream and make part of our agenda. I think the point here is that our constitutions, our laws deal at least implicitly with these issues, with justiciable socioeconomic rights and with the rights of sexual and gender minorities. All our constitutions in the South, in Africa, speak to the rights of everyone, individuals. So it does not exclude. Sometimes I think the challenge is how to make these implicit protections more explicit. So part of the questions we will ponder today would be, but why is it that these two sets of rights, the rights related to socioeconomic rights, the rights of those that are living in the most materially deprived conditions, the rights of sexual and gender minorities, why is it that these rights are often not vindicated and not protected and promoted within the global South, the South, and particularly in Africa? I think these are very interesting questions. We have a wonderful number of speakers and panels that will address these issues. Ultimately, I think it's also about how these two themes intersect and come together. In other words, how is it that material deprivation, the issue of socioeconomic rights, also in a particular way affects and intersects with someone being a lesbian, gay, transgender person. And I think towards the end of our symposium, we will in particular look at those synergies and intersections. Once again, from my side, welcome. Thank you very much for being here. We know it's a late month, a late week in the calendar, and we appreciate everyone's presence here. May I just say from the center side, I also thank those involved, Michael Nyarko, Ayo Rungo, and Teruna Naidu. So with these few words, once again, welcome. We look forward to a very interactive 2 days. Thank you.
Thank you so much, Professor Viljoen. I felt that you really gave us something incredible to think about and to look forward to as we go into the symposium. Before we move on to the next item, I wanted to just highlight some house rules. Please, in relation to naming, please name yourself accordingly on Zoom so that you know who you are when you're speaking. I would also add, if you would want to put your preferred if you want to put your pronouns on your profile, that is also important so that we avoid misgendering since we're talking about SOGIE rights. Recording, please also be informed that the webinar is being recorded. The recording of the panel discussion will be available for participants who are not present today or otherwise on request. Then we also want to speak about the muting mode. Please disable your web camera and your microphone during panelist discussion. We also have a session for question and answers. Towards the end of the webinar, the attendees will have an opportunity to ask questions. Attendees can send their questions via the chat box, and their questions will be directed to the moderator. Should you have any questions which you want to direct to a specific speaker, please indicate your question and comment. If you find yourself accidentally being kicked out of the webinar, please rejoin using the same link. And please, if you want to encourage other people who may not be able to go on the Zoom link, we have a live stream happening right now on YouTube, and the link is in the chat box. So if you want to live stream, you're welcome to do that. If you want to share the streaming of the YouTube, you're welcome to do that. And then we will go to Kanyo, who is from the International Commission of Jurists, who will say a few words and then also introduce us to our keynote speaker. Over to you, Kanyo.
Thank you very much, Letlhonolo. Excuse me, just recovering from a cold, but I'm very, very delighted to be here today. And my name is Nogukanya Farize, as Letlhonolo has mentioned, but you're welcome to call me Kanyo. I am the legal advisor here at the International Commission of Jurists, the ICJ, our Africa Regional Program. And we are based in Johannesburg. On behalf of my boss, Kajal Ramjathan Kio, who is not also feeling well today, I wish to really extend a hearty and warm ICJ welcome and greeting to every person who's here today. We have a very broad range of people who are with us today, both presenting as well as just attending. So people from academia, human rights defenders, activists, lawyers, judges, a very wide range of people who will be contributing to our very complex and interesting conversation. I think Professor Viljoen did a very good job of highlighting what brings us here today. So with that, I would really like to welcome you and to really, it's going to be interesting, the conversation we'll be having today, because it's very important for us to take a step back and just look at some of the developments that have happened in recent years in our continent. In our courts, for example, we've had litigation of issues of freedom of association and freedom of assembly. We've had important judgments around the right to dignity, equality and non-discrimination, very important judgments around the rights of transgender persons and the rights of intersex persons. We've also had judgments around decriminalization of consensual same-sex intimacy, as we've seen most recently in Botswana. We've had cases around issues of labor and employment and other issues around immigration and adoption. So our courts have been really looking very closely at the issues of sexual orientation, gender identity, and expression. But of course, as we've mentioned, these issues are always intertwined with other rights, with other fundamental human rights. At the same time, in our continent, we've seen a range of laws that discriminate against LGBT persons. We've seen the so-called sodomy laws that remain in the books of many of our countries on the continent. But we've also seen new sort of laws that are very far-reaching, as we've seen in Ghana, the proposed bill there, and also as we've seen, for example, in Uganda, the sexual offences bill, which was not passed into law. But we've seen a range of diverse laws which seek to restrict the rights of LGBT persons and further deepen discrimination. And I think that the COVID-19 pandemic has really been an occasion that has shone an enormous spotlight on the impact of these discriminatory laws on the continent. We've heard stories of people not having access to healthcare, not just only in relation to COVID-19, but also HIV-related treatment, sexual and reproductive health services, the deprioritization of various health services, including gender-affirming health services. We've seen even at the level of the African Commission a concern about the lack of access to healthcare services for especially marginalized persons during this health crisis. We've also seen issues of homelessness, where people have been left stranded without homes because, for example, they cannot continue to afford paying rental in the places that they stay in, but also because they've simply been thrown out of their homes in cases where they've been in lockdown in hostile environments. We've even seen in Uganda, for example, the raiding of homeless shelters where people are supposed to, in fact, find protection and refuge, but because of discrimination, find themselves either arbitrarily being arrested or being removed from these places of shelter. We've seen enormous shortages in food where people cannot afford to have a meal. We've heard stories of people not even being able to take their medication during this health crisis because they can't afford to buy the food with which they're supposed to take that medication. And all this has been linked to a lot of discrimination and even a huge loss in livelihood. As we know, many LGBT persons have been employed in the informal sector, hairdressing, photography, car washes in our continent, and all these places where people try to eke a livelihood have been affected by this pandemic, which means that the most marginalized, once again, finding themselves in even worse situations. We know the issue of violence and hate crimes in particular, especially in Southern Africa. We've seen quite a lot of hate crimes that have been committed against LGBT persons, in particular Black lesbian women have endured so-called corrective rape, and the increase of gender-based violence during this pandemic. We've seen how LGBT persons have been very severely impacted. And of course, the issue of violence has gained some level of recognition, even at the level of our African human rights system, that indeed LGBT persons find themselves very prone and at high risk of violence in our countries, both by state actors as well as by third parties. We've seen in some countries where kidnapping, in Nigeria, for example, the kidnapping and extortion of LGBT persons on the rise, both by state actors as well as non-state actors. We've seen how brazen criminals easily harass and intimidate and extort and kidnap LGBT persons with impunity because of discriminatory laws that exist on our continent. So this is a very timely conversation to talk about the rights, ESCR, economic, social, and cultural rights. These rights which make life worth living, the access to education. For example, we know that many LGBT persons can't even access education because of the massive discriminatory barriers that prevent them. And of course, that channels many people into a life of poverty. So there is a need to look at these rights to health, the rights to work, and many other economic, social, and cultural rights, which intersect directly with the rights that LGBT persons so desperately need to enjoy on our continent in Africa. And we've seen there's a very many progressive judgments that we will probably be talking about here today, but there's also scope for more improvement to be done on these issues on our continent. So it's really exciting that we're going to talk about very complex but very interesting areas of law that converge together today under the umbrella of the rights that we will be discussing. And so we have very intelligent, very achieved people who are going to be presenting to us and sharing very important knowledge with us. And we've seen, for example, how there is a strong populist movement and various other movements which are spreading a message of hate, a message of intolerance, a message of rights violation across our continent. But I think a platform like this is very important for various reasons, including it's very important to put the right information out about what is happening in our continent when we talk about LGBT rights, when we talk about economic, social, and cultural rights. It's important for us to spread the right message, to put the right information out there. So we have a range of experts, a range of very talented and well-achieved people who will be talking to us today, one of whom is Mr. Gilbert C. Bihogo, who today is going to be represented by Rudy Laura, who is a program officer at NANRI, who was implementing the SOGIE project. So Arudi will be representing Mr. Gilbert Sibihogo, who is the executive director at Network of African National Human Rights Institutions, NARI, which promotes the establishment of national human rights institutions throughout Africa and supports cooperation and training to strengthen and develop the monitoring, promotion, protection, and advocacy work of NANRI's, of national human rights institutions. Prior to his appointment, Mr. Gilbert served as a visiting lecturer at the Independent University of Kigali. He is also the former Prosecutor General at the Court of Appeal of Kigali and a human rights lawyer. This is but one of the very profound speakers we will have today, and later on our facilitators will introduce other panelists which we have today. But for now, I would like to hand over perhaps first to the facilitator, if there are any additional comments or announcements before we go into the keynote address by Rudy Laura on behalf of Dr. Gilbert. Over to you, Little Honolo. Thank you.
Thank you so much, Kanyo. You've just given us a mouthful to really chew on. Before we allow Rudy to give the keynote address, which we think will be very, very insightful, we just encourage all the speakers to speak slower than normal because we have French translations and we want to make sure that people who are joining us from other countries and who speak French are able to hear and follow the conversation. So we ask you to speak slowly. Rudy, thank you so much, and over to you for the keynote address.
All right. Thank you very much for this opportunity. So honorable judges, distinguished academics, researchers, and all participants joining the Global South Symposium on SOGIE and Economic and Social Cultural Rights, I welcome you to the discussion planned today and wish that all of you are well. So my name is Arudi Laura, as I have been introduced, a program officer working with the Network of African National Human Rights Institution, and I'm delivering this keynote on behalf of our Executive Director, Gilbert Sebihogo, who could not join us due to conflicting duties, but sends his greetings and applauds the two organizations, namely the International Commission of Jurists and the Center for Human Rights, for organizing this webinar that seeks to shed light on the intersectionality between SOGIE rights and economic, social and cultural rights in Africa through a judicial application lens. So the discussion is indeed relevant within Africa and a great initiative to learn and exchange around key lessons and challenges that surround the advocacy and realization of rights to SOGIE populations around the continent. So the keynote will follow this flow. First, we'll have a brief introduction into the work of the Network of African National Human Rights Institution and the work we do so far with regards to SOGIE rights. Two, we'll highlight a few cases surrounding SOGIE rights around the continent that will highlight, the development, the recent development in terms of SOGIE litigation. I'm happy that one facilitator already introduced some of the cases that surround, right to assembly, freedom, and right to dignity. The third is going to be the disparities that continue to arise in many jurisdictions as we talk about SOGIE litigation matters. And lastly, we're going to have some recommendations and conclusions. So you're very much welcome. So the Network of African National Human Rights Institution is an umbrella organization of 46 African national human rights institutions that envisions, and I quote, an African continent with an enhanced human rights and justice for all, end of quote. So this happens through supporting the establishment and the strengthening of national human rights institutions in line with the Paris principles. So as an independent legal entity registered under the Kenyan law, NANRI provides capacity building. It also facilitates coordination and cooperation among NHRIs by linking them with other key stakeholders and human rights actors at regional and international levels. One of the main mechanisms that we emphasize is the African human rights system, and we try and ensure that the African Commission on Human People's Rights and its mechanisms are as well utilized by the NHRIs. So when it comes to matters SOGIE, NANRI runs a SOGIE project that is premised on the adoption of Resolution 275 on protection against violence and other human rights violations against persons on the basis of their real or imputed sexual orientation or gender identity. This Resolution 275 was adopted by the African Commission on Human and People's Rights in 2007. So through this project, NANRI has attempted to increase the knowledge around SOGIE matters among NHRIs. So through increasing linkages between NHRIs and SOGIE CSOs within different states, with a vision of institutionalizing SOGIE within the NHRI programming. So far, NANRI has worked with NHRIs from Kenya, South Africa, Ghana, Malawi, and Uganda. And currently, we are expanding to encompass Togo, Nigeria, Namibia, Cote d'Ivoire, and Liberia. So through this project, we have observed the increased strategic advocacy and programming by the national human rights institutions with regard to SOGIE matters in their respective states, regionally, and globally. I shall highlight some of the key successes that we have noted so far. So one, in Kenya, for instance, the Kenya National Commission on Human Rights has been an active in the task force that has ensured the realization of intersex rights. This, for instance, one of the main outcomes of them being at the task force is the inclusion of intersex person within the recently concluded census in 2019. Also, another key and very historic moment for us as NANRI and NHRIs is for the South African Human Rights Commission. It was recently accepted to be a third party or a friend of the court in an ongoing case of Seminya versus Swaziland, whereby the South African Human Rights Commission seeks to highlight the adverse impacts and discriminatory effects of the regulations set out by the International Association of Athletics Federation. So the International Association of Athletic Federation seeks to get Caster Semenya to take hormonal treatment to regulate her testosterone level. And this matter intersects a lot with race and gender in sports. So in particular, the Commission, as an independent intervener, is seeking to illustrate how the impurged regulation breach Article 14, which prohibits against discrimination, as well as Article 8, which is the right of respect for private and family life, as well as Article 3, that is prohibition against torture. This is at the European Court of Human Rights. So this is a major milestone, considering that the South African Human Rights Commission is one of the first NHRIs to be given, such a momentous opportunity to contribute to the legal jurisprudence, not just within Africa, but within the region as well, global as well. So these key moves by the NHRIs cement the important role that these institutions play in protecting rights of vulnerable groups within their respective societies and states, and the significance of empowering NHRIs to protect the rights of all persons based on the non-discrimination principles. The second part of the presentation tries to look at the steady march to progress. So here we're going to try and highlight a few cases, because there are quite a lot, a few cases that have shed light on the realization of SOGIE rights in Africa. So one reality that SOGIE persons and communities contend with in Africa are the upheld social norms, cultures, and religions that many African states ascribe to, and which are concocted or perceived not to be accommodating of the sexual and gender diversities that exist and continues to exist within the global South. This being stated, it is clear that these notions result in the exclusion, denial of existence, vast human rights violations, and repression of identities, sexualities, and relations that are non-conformist to the majoritarian population and ideologies. The judiciary, being one arm of the government that should be impartial in its dispensation of duties, is one avenue among many that SOGIE persons and communities have resorted to in a bid to seek justice, to uphold the rule of law, democracy, to interpret the constitutionality of laws and policy within the states. So therefore, in Africa, the utilization of the judiciary as a legitimate entity has shed light into the discriminatory laws that are upheld in many legislatures in states with regard to SOGIE persons. So let's have a look at a few cases. So one of the cases that I will highlight is the freedom of association and expression. So first of all, a background on this. So the right to freedom of association is provided for in Article 10 of the African Charter, or the Banjul Charter, as well as across many national constitutions in Africa. This being said, as a result of the upheld negative notions surrounding sexual and gender identities that constitute the SOGIE group, it has been seen that many states have denied the realization of these rights in many jurisdictions. This is withstanding the guidelines on freedom of association and assembly that were drafted by the African Commission on Human and People's Rights, adopted during the 60th session, ordinary session, between the 8th to the 22nd May of 2017. One of the principles of the guideline with respect to SOGIE is, and I quote, every person has the right to establish an association together with another, free from limitation, violating the right to equality and the guarantee of non-discrimination. End of quote. So in the light of the denial to register, we have seen the utilization of court in this matter. One of the standing cases is the Lgbti case versus the NGO Coordination Board that was held in Kenya in the year 2013. So in this case, Lgbti sought to register an NGO which would seek to address the violence and human rights abuses suffered by LGBTIQ persons in Kenya. So the petition raised various questions on the freedom of association and non-discrimination and equality before the law with regards to persons who belong to the LGBTIQ group. It sought to answer two main questions, which I will highlight. The first question was whether such persons have a right to form association in accordance with the law, and two, if the answer is in the affirmative, whether the decision of the board to allow the registration of the proposed NGO because of the choice of name is a violation of the right of the petitioner under Article 36 and 27 of the Constitution of Kenya. So thereby the courts luckily ruled in favor of Lgbti and of the petitioner and said that the NGO board and the Attorney General relied on the moral and religious convictions. The Constitution of Kenya, however, does not limit grounds on this, on this ground, and it seeks to protect those with unpopular views, minorities, and rights that attach to human being, regardless of a majority's view. Therefore, the NGO board was asked to register the organization. The implementation, however, of this decision is still pending as we speak. Another case that comes about is in Botswana, whereby the applicants belonging to an organization called the Lesbian, Gay, and Bisexual Botswana, famously Lgbti, filed this application to challenge the Minister of Labor and Home Affairs, who also rejected the applicant's registration of the organization. The minister was set aside and the court declared that the applicants were entitled to register Lgbti as a society. On the freedom of expression as well, we moved to Zambia. So in Zambia, there was a case in 2014, the People versus Paul Kasonkomona. Pardon me if I violate the name. So this case concerned an appeal to the Zambian High Court by the appellant against the respondent of the magistrate court. In this, the respondent, who is a human rights activist, was invited to engage in a discussion on homosexual rights in Zambia's television program. So the respondent was thereafter accused of soliciting, I quote, soliciting for immoral purposes. He was arrested and subsequently charged with the offense of idle and disorderly conduct under Section 178G of the Penal Code and Cap 87 of the laws of Zambia. So the court again came in and agreed with the trial magistrate that the respondent conduct of participating in a debate advocating for gay rights did not amount to soliciting for immoral purposes. The court also agreed that the respondent's right to freedom of expression could not be limited in this instance. We move to another right, that is the right to dignity. Within the right to dignity, we have a case in Ukunda. We're back to Kenya. So this case, a brief background on the case. is the appellants of this case were arrested on the 18th of February 2015, where they were having some engagements, some pleasure time in a bar in Diani. On this, they were suspected of engaging in gay activities as well as distributing pornographic material. According to one of the investigating officers named Salim Yunis, about 10 compact discs containing pornographic material were retrieved from one of the appellant's house. An attempt by the police also brought, and the magistrate court asked that the appellants undergo a medical examination, that is the annual examination, in order for their case to be thwarted. So, based on this, the Court of Appeal upheld that the medical examination that was carried out to the appellant was a violation of various constitutional rights, some of them being the right to fair trial and the right not to self-incriminate, the violation of privacy and dignity, as the annual examinations are a form of inhuman and degrading treatment. So following this case, it's good to announce that Kenya declared the first annual examination, they were abolished. So that was a step ahead and progress in terms of the realization of SOGIE rights. So let's look at a bit of transgender rights. So in a case of September and Subramani, which is in South Africa, it took place between 2016 to 2019. So in this case, it's a trans woman who was or is incarcerated in one of the correctional centers. And they brought forward, or rather she brought forward, an application to be allowed to express her gender identity while in prison. So the applicants are those who are not conversant with transgender rights. So the applicant was born male and assigned male, and currently anatomically still male. Therefore, they were held in the men's section in the various correctional facilities that they were held in. So during her detention, she experienced resistance from wardens in expressing her gender identity. And the court also ruled that the applicant, that until the applicant has undergone gender reassignment treatment, the respondents are directed to take reasonable steps to give effect to the applicant's constitutional right by allowing her to express her gender identity and separating her from male cellmates by providing a single cell for her or transferring her to a single cell in a women's correctional facilities. So throughout these few cases that I have highlighted, we see the progress of SOGIE rights through the adjudication or the utilization of the court. However, part 3 of my presentation brings some foreseen challenges or some challenges that are seen. One of the challenges is the religious doctrines, So in many African states, the use of religious rhetoric has been used to limit the rights that SOGIE persons are entitled to. This debate has taken foot in making of laws and in respondents' arguments in various cases. So the court is thus faced with a challenge between religious freedom and conscience and its application in laws. And as you remember, one of the cases in the registration case, the court said that religious beliefs cannot be used to validate violation of some rights. 2, African values. So this is a claim that is continuously used to justify laws that discriminate SOGIE persons in African society. we see it arise in the newly widely debated Same-Sex Act bill that is currently ongoing in Ghana. It is well noted that this argument that protecting the rights of LGBTIQ persons would distract the African family values is actually not based on any credible evidence. As one, the SOGIE community is part and parcel of the family unit. They come from a family unit, and so many of them in many ways contribute positively to the families that they are head or are part of. And just to emphasize on this, there was a good precedent set in Namibia where a gay couple wanted to adopt a child, and the court ruled in their favor, and they got to bring their child home with them from South Africa. Another challenge that we face is political interference. So this, I'm going to highlight the revocation of observer status for the Coalition of African Lesbians that was done in 2018 by the Executive Council. So this shows, the interference of the independence of institutions mandated to protect and uphold human rights in society. So therefore, as the public opinion as well is one of the greatest impediments or challenges that we face, I will quote from the S versus Makwanyane case that happened in 1995, whereby the court said, public opinion may have some relevance to the inquiry, but in itself, it is no substitute for the duty vested in the courts to interpret the Constitution and to uphold its provision without fear or favor. So in conclusion, therefore, litigation around SOGIE rights in Africa has been gaining a lot of momentum. And due to the vast cases covering a range of human rights issues that are enshrined within the human rights system, as well as the international human rights framework, it shows that first, there's hope for cross-referencing of decisions by various courts while adjudicating on SOGIE matters. It also shows that there's a sign or there's hope for African judicial dialogue as it relates to contentious issues and matters, for instance, SOGIE persons. Some recommendations, therefore, moving forward would be, one, to strengthen litigations, to set precedences, to strengthen strategic litigation tactics or interventions, to set precedences, and to even trigger legal reforms. And we've seen this in various issues due to strategic advocacy and strategic litigation, for instance. We have seen in Uganda, for instance, the Sexual Offences Act that was to be assented was withdrawn. We have also seen through various parliamentary actions, countries, for instance, Gabon, have been able to decriminalize SOGIE martyrs. So therefore, strategic advocacy and litigation is a good precedent. As well, we know, or we are aware, that litigation is a long process and it has a very high cost. And therefore, it is one of our recommendations is to seek further collaborations in such initiatives. 3, capacity building and sensitization. We can never say enough of this. And capacity building of judicial officers, police, and other stakeholders within the justice system and beyond to better understand and to better interpret the laws in accordance to the various treaties and obligations that the states have assigned to is something that is widely recommended and encouraged. And of course, we hope that there'll be further litigation and further mechanisms seeking to bring more litigation and more precedence on SOGIE matters on the national level, in the regional level, as well as in the international level. Of course, guided by the laws and the principles of human rights. So thank you very much for the chance, and we look forward to more conversation around this. Over to you, facilitator.
Wow, what a wonderful, 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 wonderful keynote address of just canvassing what it actually means to go through what the legal precedents have said. I think that was quite a mouthful. One thing that was really interesting for me was the mention about Caster Semenya's case, which is now at the European Court of Human Rights. And an interesting fact is that the International Commission of Jurists have already been have submitted third-party interventions in that case. So it'd be interesting to see what the European Court comes up to. And next, we're going to continue this conversation about legal precedences with a panel discussion, which will be facilitated by Taruna Naidu from the Center for Human Rights. And she will introduce a wonderful, wonderful array of panelists. The panel will be on querying the judiciary in Africa, navigating differences and diversity under the doctrine of precedent. Taruna, over to you.
Hi, good morning, everyone, and thank you for joining us this morning. I have the exciting task of moderating this panel, which is called Querying the Judiciary in Africa, so navigating the difference and diversity under the doctrine of precedent. And on our panel today, we have with us Dr. Rudo Chigudu from the University of Pretoria. To introduce Rudo, Rudo is an activist, artist, mentor, and coach who is committed to social justice, particularly sexual and reproductive health rights. She has 6 years experience in community activism and development project design and implementation. Over the years, she has acquired vast experience in training and workshop facilitation, project management, communication, negotiation, and conflict resolution skills, and is also an experienced public speaker with great networking skills. As a performing artist, she uses arts as a tool for advocacy, self-expression, and public awareness. Combining rights knowledge with creative arts, Rudo seeks to engage in more meaningful social justice for women in the social, economic, and political arenas. She has also been a recipient of the Human Rights Defender Awards in 2011 and 2013 by Crisis Coalition in Zimbabwe and Zim Rights, respectively. So we're so honored to have a speaker like Rudo with us. And joining her on our panel is Professor Chidi Odinkalu. So Professor Chidi is a Nigerian lawyer and human rights activist based in Abuja, Nigeria. He obtained his PhD in law from the London School of Economics and Political Science. He is currently the senior team manager for the Africa program of the Open Society Justice Initiative and has extensive networks across Africa built up over several years of working for human rights and social justice on the continent. He is also the founder of the section on public interest and development law at the Nigerian Bar and member of the executive committee of the Nigerian Bar Association. Professor Chidi is currently at the Fletcher School of Law and Diplomacy in Tufts University, based in Massachusetts. So with us, we also expected to have Dr. Stella Nyanzi, but Dr. Stella has not logged in yet. So I think we will start the discussion with Rudo and then move on, and I will introduce Stella once she joins us. Thank you. So good morning, Rudo, and thank you for joining us. I'd like to know from your perspective, how would you view the jurisprudence that we are now seeing emerge on the continent? I think based on Gilbert's keynote address, we can understand that once litigation around queer rights and SOGIE rights in Africa began, there was heavy resistance within the court system. However, over the years, the jurisprudence has slowly started to shift as human rights has impacted the way that the courts now adjudicate matters that relate to SOGIE rights, even in environments where there is legislation that effectively continues to criminalize same-sex intimacy between queer people in Africa.
Thank you, Torina. Thank you to the other panelists who are joining me on this panel, to the organizers. It's always exciting to get an opportunity to speak on LGBTQ rights issues. I think one of the things, Truna, when you talk about the evolution on the continent, one of the things is that on one hand, we're engaging the ways in which judicial systems can better protect the rights and interests of people based on their sexual orientation or gender expression, and the ways this has evolved on the continent over time. And thanks to the earlier keynote that really flagged the cases and kind of judgments that we've seen across the continent, I'm not going to belabor that or go back into discussing the cases, but really to say that we see in the cases and judgments that have already been mentioned, with I think Botswana being the latest victory, the way this has continued to catalyze the process of grappling with marginalization and social exclusion by recognizing the diverse nature of individuals and relationships and families across the continent. The legal cases and victories, however few they've been, are testament to the potential of the judiciary to adapt and move away from the more traditional understanding of social legal phenomena and creating a more inclusive environment that is hinged more on constitutional morality rather than what we've been seeing and experiencing on the continent, which is the dominance of social morality. And we've had numerous cases going back to Banana, I think in Zimbabwe, where the court was saying we do not, our aim is not to be seen as being at the cutting edge of legal development when it comes to matters of LGBTQ persons, and seeing more and more a transition in that regard. What is of particular interest to me is that it has often been argued that the judiciary, being the embodiment of justice, tends to fall behind in being proactive to include members of the queer community within its structures. And so there's something here that needs to be said about the fact that when we want to think about making progress, when we think about transformation, the issue of visibility and representation is of significance in the space. So whilst we see that there have been milestones like you highlighted, Taruna, we see milestones, we see victories in court cases, and even where we don't have legal victories, but where litigation takes place, and conversations are increasingly on the lips of our communities and societies in ways that haven't always been the case in the past. So we are saying there's definitely a transition, there's definitely a change that we're observing in terms of the engagement of our societies and of our judiciaries. The tension, I think, for me sits in the place where, or my interest sits in the place of recognizing that on one hand, it is easy to see the LGBT category as this mass, this lump. And it's easy to talk about the lump or the mass of individuals that are included in the category, because there's a history of struggle, there's a history of collective fight that comes with this category. And so there's mileage in continuing to advance rights issues with the category lumped in that manner. So I'm not dismissing that. But I think there's a lot to be said about what also gets lost in the category. So I'll use a simple example of how a country would say or would talk about homosexuality. And by homosexuality, everyone, whether you're talking about trans, lesbian, bisexual, everything is lumped into that one category. And so where regulation exists, what the letter of the law states ceases to be the dominant issue. It's merely that homosexuality is illegal. And so everything LGBTQI+ is seen as illegal. So even where individuals within that category aren't being criminalized or aren't regulated in particular ways, the existence of the category in that form also means that everyone is carried along. And so it's really to say in the moments where there's benefit, where you are saying collectively, there's this category of people when we're talking about sexual orientation and gender expression, whose interests and protections matter, then it carries across the group. But where there's victimization, where there's violence, where there's criminalization, even when not everyone is criminalized, the lumping also means that everybody else in that category carries the weight. So I think of interest to me is to actually see a more explicit naming, deconstruction of the category, to talk more explicitly, because what that allows us to do, and this for me, I think is particularly important in thinking about queering the judiciary. What is it in an intersectional approach that we could benefit from when we are thinking about this category of people? Because the reality of a white middle-class gay man is not the same reality of a working class lesbian living in a high density community or in a more closed community. And so I think for me, the interest is really in thinking about how do we stretch the categories in ways that allow the protections to be cognizant of the ways in which we are gendered and classed and raced within this LGBT category. And I see your camera is on, so I'm going to stop there.
Hi, Rudo. Thank you so much. I think maybe to follow up, I would like to ask about specific interest groups within the community. So as we picked up from the keynote discussion, the approach to minority groups within the broader LGBTIQ+ community has been slightly different. So in Gilbert's address, he discussed the Jade September case and how it impacts the rights of arrested and detained persons. So as these groups have had a more recent emergence into the general visibility within the population, I think that the opportunities for strategic litigation for their interests may differ. And I wanted to hear from your perspective, are there any specific opportunities that we can focus on within the continent? So not just for trans rights specifically, maybe as well for trans and non-binary persons, as well as the intersex community, or the LBQ women's movement, which I think you might be best able to speak to. So if you could just give me your thoughts on that, I think that would be really helpful. Thank you.
Thank you for that, Tuna. I think certainly opportunities exist constantly. I keep saying whenever there's resistance, it shows you that there's possibility for change. And so I think I think this is one of the, I'm always very wary of the ways in which groups can be instrumentalized for the benefit of the masses, and often at the expense of those groups themselves. And maybe to just make that a little bit clearer, one of the things I was thinking about was the fact that where arguments have been made about homosexuality, gay men, lesbian women as these nonsense ideas of being unnatural, of being alien, of being Western, whatever it is that has been tagged. When you look at a category of people like the intersex community, where the realities of biology and physicality compel us to say this idea that we come gendered in these very fixed and binary ways are actually a falsity, right? And so it makes sense that when you are having conversations that seek to disrupt this very binary approach to looking at gender, is that the intersex community offers an in. And the tensions, I think, have already been highlighted, that on face value, we can talk about rights and rights protections. But when we get to the place of engagement in society, so by this I'm talking about challenging issues such as gender assignment, assigning sex at birth for the intersex community. And so when you are legally fighting cases of that nature, I think we have a better opportunity, that the opportunity is there. And it's easier to make a rights argument. But we still have the same kind of tensions that you have, as we see with Caster Semenya, when we are looking at individual lives later, and this discomfort of not knowing if we haven't boxed you neatly at birth, we don't know what to do with you later in life. So I think there's an opportunity there when we are when we are thinking about how we engage with certain groups, and what opportunities individual groups within this category present, what exists. Talking about lesbian women, for instance, is that, like I was saying earlier, one of the opportunities was the fact that in many countries, same-sex relationships between women weren't actually criminalized across the continent. In many countries on the continent, weren't criminalized explicitly. In Zimbabwe specifically, we were talking about sodomy, and it was very clear that it was sex between men. And part of the evolution of this rights transformation and equality, and this asserting of visibility of individual categories and visibilizing lesbian women, actually brings them into the lens where the restrictions can actually dangerously increase. So I think there's something there that needs to be said in terms of opportunity, knowing when it's strategic to visibilize individuals or groups within the broader categories, because in some instances, the visibility actually results in backlash. And on one hand, part of my belief is that the backlash is part of the beginning process, that it's inevitable. If we don't have backlash, we can't see transformation. But it's about knowing what moments it is strategic or ideal to engage in such progress. Because I know in Zimbabwe, when we started to talk about lesbian women and visibilize, it was literally drawing attention to the fact that we were not being criminalized in the same way that gay men were being criminalized, and what the consequence of that, right? And being prepared to sort of prevent that level that level of backlash that we risk. But I definitely think that there are other opportunities that exist for us to engage.
All right, thank you so much. We are now joined by Dr. Chidi. Thank you so much for joining in. We had encountered some network connectivity issues, but I will allow you to take the floor and address the panel. We are currently discussing as to whether there are any unique opportunities for specific minority groups within the LGBTI space across the continent. And you're also welcome to share your perspectives as to how the litigation has really evolved over the years and the impact of human rights norms and human rights norms on the jurisprudence that is coming out of the courts. Thank you.
Sorry, good morning. I don't know whether you hear me okay, because I'm sorry, I've been on the road and I'm speaking from a part of the world in which connectivity is somewhat challenging, slightly. So if you hear me, that's okay. If you don't hear me, I hope I'll be able to come across in some form. Secondly, and because of that, I should apologize. I've missed much of what's transpired, everything, indeed. Because of that, my people have a proverb that the person who's late to the funeral starts attending to the body from the wrong part of the anatomy. So that basically means that anything I say here may well be out of whack and out of point. And I should therefore apologize for that ahead of time. I mean, this conversation is taking place the week after the Botswana Court of Appeal decided the appeal on decriminalization, which is the first apex court opinion on the point across the continent. And with the exception, I believe, of Southern Africa, views, judicial points of view on the question, our judicial approaches generally to the issue of sexual minorities on the continent remain rather somewhat outdated. At the very best. I also tend to think they are pusillanimous. They are really lacking in imagination and courage. But I don't think this necessarily should be a dump on the judiciary, because we need to step back a bit and look at both the political context and the legislative frameworks that we live in. The legislative frameworks, of course, are caught up in the Victorian time war, which is when a lot of the anti-sexual minorities laws made it into our laws around the continent. Much of these were part of the legislative framework introduced by colonists on the continent sometime around sometime between 1870 and 1890, thereabouts, latest 1900. And Queen Victoria, of course, died in 1901. So this is the first thing, that we are dealing with a lot of places in which the laws are still in arrears. And as long as many of those laws are on the books, we've got a job of legislative advocacy as well, as rudimentary as that sounds. Lagos State in Nigeria is the first state out of 37 territories, because Nigeria, indeed out of 38 legal systems, Nigeria is 38 legal systems, which is 36 states, 1 federal capital territory, and a federal legal system. That's 38. Out of 38 legal systems, Lagos State is the first state to have decriminalized being a sexual minority as a crime successfully. Another state in Nigeria, Imo State, which is in the southeast, attempted to do that. But then, indeed, the law was passed and signed into law and then scrapped because the governor discovered that he needed Catholic votes to get back into power. And the local bishop told him that if that law was not scrapped, it was going to mean that he could not return to power. But in Lagos State as well, you have a police force that is federal, and the federal police force can apply and does apply the Same-Sex Marriage Prohibition Act, which is a federal piece of legislation that was put in place in 2015. Now, that piece of legislation has meant that this is, by the way, a country in which being gay was already criminal. So how people could contemplate the idea of same-sex marriage prohibition was beyond anyone other than legislative surplusage. But then it has become it has created a vast market for the police. And what they do is, if you're a young person walking on the road and you have a laptop or you've got a PDA of sorts that's got some capabilities, and the police officer looks at you and doesn't have money in their pockets, they approach you, tap you on the back and tell you that you're looking gay. And because you're looking gay, now you ask yourself, what does looking gay mean? All right. And they tell you that you're looking gay, and because of that, you should come with them. And you're imprisoned, you're arrested, you're detained. They then send you to court the following morning and get you committed to pretrial detention under the Same-Sex Marriage Prohibition Act, unless you do what? Part with money. And so this has become a massive extortion market and racket for the law enforcement agents. God, absolutely, because nobody is going to get into that realm in the legislative framework that countries like Nigeria have. But yet, what happens? This is what is happening. It's being used by law enforcement agents to abuse a whole generation of young people, and even worse, make money out of that abuse. And the system does not offer any redress, coherent, lawful redress for this kind of thing. And in my view, this is one opportunity for action. Now, and I say this, but such basic things as the protection of people, irrespective of who they are, what they look like, how they dress, where they come from, worship, or who they choose to or to not sleep with, should not be negotiated in any society. And when there is such unlawfulness by law enforcement agencies, the capacity to offer protection and remedies should be not negotiable. So for me, this is one of the first things we've got to do at the moment. The groups that do such advocacy in Nigeria, for instance, are in a very difficult situation. And much of what they do is try to get these abused young people, being abused by the legal system, out of the clutches of law enforcement, quite often through negotiation, most of the time. Same. I don't know whether you're hearing me. It's only in a few cases where you can even think of going to court to apply for bail. So this is how basic and rudimentary this conversation is, applying for bail for people being persecuted by the legal system as a result of being sexual minorities. For me, that's one. And it's not just in Nigeria, in a lot of the Neo-Saharan belt of Africa, these issues exist. And it defies the distinction between Anglophone and Francophone and all the phones. You're not likely to get much more purchase in, say, Senegal. Why is this so? Senegal, for instance, is the West African headquarters of the Tijaniya Brotherhood. And Nigeria has a vast Tijaniya. Nigeria is the biggest Tijaniya population in the continent. The Tijaniya started, of course, around 1882-83, which is the onset of the Victorian conquest of Africa. Formal colonial conquest began, of course, in Berlin in November 1884 to February 1885. The Tijaniya started spreading around that time from Algeria, which was where Sheikh Tijani came from, through Morocco, which was where he was based, and right down the west coast of Africa up to parts of Gabon, which is how the Bongos in Gabon are. Tijaniya are very significant in the Tijaniya territories, are very significant in this. Across all of West Africa, the attitudes are pretty much the same. How we establish dialogue with the clerics of all sects, both Christian and Muslim, is a second issue that we've got to address in this. And there are clerics, of course, who are open on the question. Don't forget that the Catholic Church itself, seminaries of the Catholic Church, as a matter of fact, do have their own issues. And I know that in a few of the countries in the region now, they are beginning to address the question. As a result, there are clerics with whom we can actually have dialogue. How we frame that dialogue is important. Whether we frame it, in my view, is not negotiable. I do think that needs to be done. And I will end with the question of the African continent and how it engages with these issues, given the jurisprudence that's come out of on this, both the practice of the African Commission with reference to, and the African Union with reference to the case that came out of the African Court ultimately on the question of observer status of several groups, and how the jurisprudence was framed to make sure that the observer status of the group that I'm sure all of us know about was denied. Now, the pressure from, in this case, of course, the vote was closed at the African Commission, we all know that. But after the African Commission eventually got the vote together, the African Union decided that this was a step too far and decided that they were going to strip the African Union of its decision-making capacity and independence. And of course, the attempt to get this through on an advisory opinion suffered a fate that was predictable, given the way the case was framed. And I think it's necessary to return to that question and ask questions about how re-engagement can take place on this issue with the African regional human rights system before, in fact, we can return to the African court. I'll stop there and listen as the conversation evolves. Thank you very much.
Thank you very much, Prof. Chidi. I think it's very important to take away from your inputs that when we are discussing issues of discrimination against LGBTI plus people, other factors also heavily impact the way that you experience your discrimination within the legal system. So the example you use, I think we can all associate quite well with the NSARS movement and how young people are often targeted and face discrimination across a multiplicity of identities that they hold. So I'd like to move on and introduce everyone to our next panelist who has joined us. So we will be joined by Monika Tabengwa, who is a human rights lawyer from Botswana. She holds a master's in law degree from the University of Pretoria's Center for Human Rights and has served as the executive director for Pan-Africa ILGA and is a social justice activist, feminist, and legal professional with extensive experience in human rights and social justice advocacy, extending to regional and international human rights mechanisms. Monika has also served under the Human Rights Watch Lgbti program as a researcher and has conducted research and documentation of human rights violations with a specific focus on the rights of sexual and gender minorities in Africa. She has extensive experience in gender and rights-based training and strategic litigation. And Monika is currently with the UNDP LGBTI Inclusion in Africa project. So thank you so much for joining us today, Monika. And I think I'm not going to pose a specific question to you because I think you have such a wealth of experience under your belt. And I'd just like to hear your thoughts on today's panel discussion and the topic that we had assigned. So please feel free to start your intervention. Yeah, and welcome, and thank you very much for joining us.
Yeah, thank you. I'm curious to know where you got all of that stuff from. But, well, thank you for that extensive introduction. As indicated, yeah, I am with UNDP, a policy specialist that works specifically on LGBTI inclusion in Africa. It is important to mention I am from Botswana. I joined late today. I wasn't anticipating that I would be speaking, but you know, it's part of what we do is being able to rise up to the occasion and you know, be part of a discourse as important as this. My understanding is it's that we are talking about queering the judiciary or judicial discourse as it happens across the continent. So I'm not going to be very long because I wasn't prepared, but just to give a few thoughts that I feel, you know, there are some things that we can work on, and I think Botswana is a good example of you know, taking the time to kind of invest in a lot of effort in work to ensure that your goal is achieved in the way that you want. We have to remember that the judiciary, not everyone had the training or the exposure to LGBTI issues, or even just using international treaties, international human rights treaties within just giving judgments. And so it is important to engage the judiciary to ensure that they get the information and they are trained in just, you know, as naturally reaching into international law as well as the, you know, existing national or precedents, you know, reaching into that rich cadre of law to interpret our constitutions. We all know that our constitutions don't mention sexual orientation, gender identity, or any other language connecting LGBTI issues. And so in order to bring it in, you have to actually, you know, read in a lot of that language, where it says sex or whether it says gender. You have to be able to expand that, and to do that, you have to really go larger. You have to go out of the usual boxes, the usual space, and the judiciary needs to be trained to do that. And it's not just the judiciary, the court space, you have lawyers going into that. And sometimes the judiciary actually needs to be pushed in that direction. And so you need lawyers who are, you know, who are have the information, who have the skills, who know how to push the judiciary or a judge in the direction that you want them to interpret, whether it's the right to privacy or body autonomy or whatever right, but be able to pick up those pieces of international law, to get the judiciary to actually, use them. And so what you see with Botswana, I think we have a very clear case. We started in the early 90s, we had the Kanani case. And, the Kanani case, because at the time there was no real introduction of all of these pieces of law that could have helped us to expand the constitution in a way that is more inclusive, we ended up with a verdict that actually excluded. And that set us back, and that we needed to then think about doing more to ensure that the judiciary as well as the lawyers understood that we cannot just work on the constitution alone. There's a reason why countries ratify all these international treaties, and we have a right to be able to use those treaties, to expand and include sexual and gender minorities. I think the thing that courts work on is evidence, and I think research is important, just to really conceptualize issues and crystallize them in a way that people understand, or judges understand, or legal processes understand. And so when you have a research that is presented and that gives evidence. For instance, in Botswana, when the initial decree was presented in the High Court, they thought about the case. The reason why we lost in the early case was that the country was not ready to decriminalize. There was nothing that showed that the change had happened for it to decriminalize. So what they did was to do research, to build a body of evidence that showed that things had changed. There were visible people in Botswana who were openly gay. There's changes in just how the government structures itself. There's a lot of work around key populations, which include LGBTI issues. There was even a change in the employment law that actually specified sexual orientation as a ground for non-discrimination, and many other changes. And so that research, gathered all that evidence together, and also showed that, there is real harm to people when they are criminalized, and when their way of life or when their identities are criminalized. There is real harm that is felt in many different ways. And the harm is not even just felt by LGBTI persons. It's by extension, it's felt by the whole community, because once we exclude a section of a community, it affects the welfare of the whole nation. And so that evidence and that that research, I think it broke down exactly the harm that a constitution or a Bill of Rights is saying we are all equal before the law, and we deserve our dignity to be protected. And clearly, having a community whose way of life, or whose identity, or whose personhood is criminalized, and then it really becomes a wellness or a welfare issue for everyone. And so I think research is important as well. You have people. When you have people, that research has to have people behind it. The people to talk to it. You need that experts to be able to appear in court and give that kind of gravitas to the court and to the evidence itself. And so I think it's a lot of work that we have to do, and I see a lot of that happening around the continent. When we do strategic litigation, we can't just go on feeling alone, on emotive push. there has to be work behind that builds a discourse. There has to be discussions. It has to be intersectional. I think the previous speakers were speaking about how, we need to be able to connect the dots and connect the movements with each other, not just LGBTI. I think, going from, even the so-called mainstream organizations and ensuring that, we are all in this. There's a consensus at least that we do no harm. We ensure that no one is left behind. And by that, just making sure that the Constitution and all its structures include LGBTI persons. And so I think these are just really brief remarks that under very short notice, I think it's a way of ensuring that our judiciary does its due diligence in delivering justice to LGBTI. When we go for strategic litigation, I think it's not just about the issue. I think we all know. I mean, we've gotten the judgment in Botswana, but it's changed the text. So how do we translate that into real issues? Into real action? How do we get from the judgment to the change that we want? How do we get, not just the text, how do we get people feeling included, feeling to be like, now we are part of this dream nation that is free? And so I think these are some of the issues when we think about strategic litigation, when we think about issues around that, and it's some of the things that we need to consider. Thank you for giving me the opportunity. Yeah, that's it.
Okay, thank you so much, Monika. Your input has been very valuable for the context of this discussion. I'd just like to keep an eye on time, as we should be wrapping up the panel discussion soon. However, I would like to send a question to Professor Chidi, and I'd like to ask, based on your experience within the Nigerian context, can you share how development towards a strategic litigation campaign has been going? Is that something that will be on the table soon? And what are the specific challenges that you're facing in the West African context?
I don't know whether I am very qualified to answer that question, because I no longer consider myself a lawyer, really, as such. So I am a former lawyer, very much. So so anything I give you, please take with a vast health warning. I cannot claim that I know anything about the Nigerian judiciary or Nigerian judges or legal system, because they don't do law, they do voodoo. And so if you're asking me to tell you about a system of voodoo that masquerades as jurisprudence, I cannot do that, in honesty. But I also think that there is a tendency amongst lawyers to think that we can litigate everything out of existence, and therefore forget that law reflects politics, and forget the back room of law and lawyering. In legal profession will tell you not every country has a Justice Kirby, for instance, who will come up with this kind of judgment in Botswana, or Justice Cameron in South Africa, or indeed the histories of South Africa, which have made South Africa's outlook on these issues what it is. The judiciaries of West Africa are extraordinarily conservative in the very colonial and colonized sense. And if you don't engage in the prejudicial activisms and prejudicial strategies, which are essentially political, you lend yourself to guillotine jurisprudence by the time you get into court. And sadly, that is what this matter is. Now, there is no amount of judicial training that is going to train you out of this. This is where I am not, in West Africa, I'm reflecting my own limited opinion of the West African context. No amount of judicial training will get you out of this. And interpretation, jurisprudence and interpretation, I've been to judicial training programs and I've run quite a good number in pretty much every continent of the world. And I can say if that is what judicial training is, it's not going to work in West Africa. You're not going to train any judges and jurisprudence or magistrates out of ingrained institutional homophobia. No. Now, and part of this is not actually judicial. It is political. It is social pressure also that lends them to this. And so where I see we can begin, and that's where I put it as my first issue, is protection. It sounds rather irrelevant because it is not quite smack bang in the sexual minorities territory. But nobody should be allowed the license to treat somebody else differently and beneath the law because that person to them is different. If we're even negotiating that point, you will see why it is impossible. Or if we are stuck in that point, you see why it is nearly impossible to even talk about strategic jurisprudence or strategic litigation to deal with the core of the issues of sexual minorities. But the issue for me, where there is a red hot opportunity to make a break and a difference, is the protection of people, irrespective of their sexuality. I do think there is scope there. The Same-Sex Marriage Prohibition Act should be attacked, even if it produces limited jurisprudence or limited opportunity. I do think there is an opportunity in there for some litigation, and I think that is possible. But the third thing is it needs to be very thoughtfully framed. And this is where I believe many of us who do strategic litigation fail, that we think failing is good. So let's just get the case into court, irrespective of how it is framed. I do think that if we're going to get into court, we need to get into court very imaginatively and with lawyers who don't like losing. I don't think it's fashionable to just go to court and lose. And if you lose, you've got to make sure you scratch the judicial system and make it bleed. But we don't do that enough. Those will be the, I can get into details of this, having told you that I'm not a lawyer, or I used to be a lawyer. I can get into the details of this, but I don't think we make the legal system and political system bleed enough when we get into court. I can elaborate if at another moment, because I think time is an issue here. Thank you.
Thank you so much, Professor Chidi, and I apologize for putting you on the spot. I think for the interest of time, I would like to hand over to Letlogonolo so that we can begin the question and answer session. But I would really like to thank all of our panelists for providing their insight and sharing their views on this topic. I think that we can all take away a lot of key points from this discussion, including that querying the judiciary is a project that will require an intersectional focus. And there are many points of resistance that will need to be challenged. However, like Prof. Chidi has just mentioned, it's important to still engage in that practice of resisting and trying to reform the judiciary, even in instances where the homophobia or transphobia is deeply ingrained within the institution itself. So I will hand over to Letlogonolo so that we can take questions and comments. And if we are allowed an extension, I think I will just give each panelist the opportunity to address one or two final questions. But thank you very much. And we can now begin the next session.
Thank you so much. It seemed to have been a very riveting discussion I see there was already some chatter happening in the chat box. And what I'll do is I'll read some of what has been said, which I think largely some of the panelists have already answered in response to your question, Taruna. One panelist says, as we also focus on litigation, it may be important to also include the justice system officers like judges. The engagement cannot only be at the foot of the court, but in the capacity building and engagement in workshops to understand their ways of working. This will be key in formation of cases on SOGIE, as well as to help them understand the LGBTI rights are like any other rights and must be protected in similar ways as other rights. Nothing wrong with also engaging Parliament. And I think it's also interesting to note that a lot of what has been said has been, how changes happen through the court means, but there are some countries in Africa that have decriminalized and sort of worked using the legislative means. And we also need to kind of spotlight those countries so that we know that there are many routes to, to skin a cat. And I see then there's another question here. The question is, hello, everyone. I'd like to find out what the role of the NHRC has been in curbing violence against LGBTIQI plus persons in Nigeria. Are there any reports of violence against these groups documented by the NHRC? I think that may be to Professor Chidi, if Professor Chidi has any information, and any of the other panelists. And I see another comment here, and I encourage you as people participating, if you have any comments or questions, please give them out in the chat box and we'll read them out to the panelists. Another one is strategic litigation on LGBTI issues in Nigeria is slow paced and met with several challenges. There is also a clear divide amongst lawyers where the subject matter has to do with SOGIE. There's several efforts to equip lawyers with necessary skills to challenge the status quo on SOGIE. It's a work in progress. So Taruna, I think there's one question with relation to, the documentation of Nigerian Human Rights Commission. If anyone has any information about that, and I'll keep monitoring the chat box to see whether there are any other questions.
Okay.
I can address the question on the Nigerian Human Rights Commission. I presume because I chaired the Nigerian National Human Rights Commission for 4 years, between the end of 2011 and the end of 2015. And in that time, I tried to drag the commission into engagement on these issues. It was actually in my time as the chair that the Same-Sex Marriage Prohibition Act was adopted. And while that law was being adopted, so let me tell you my own limited story on this issue here. While that law was being adopted, I made contact with both chambers of the National Assembly, because Nigeria, of course, has got a bicameral federal legislature. And as the chair of the National Human Rights Commission, and sought to meet with them. In the end, I went into negotiation with the then Speaker of the House of Representatives, and he most reluctantly, after prolonged negotiations with his deputy, with his chief whip, agreed that I should come and address them on the floor in plenary, on the floor of the House of Representatives, which was an extraordinary privilege. Because generally, of course, Parliament doesn't allow, you can address them in committee, but I addressed the plenary on this issue. And they thought it took a lot of gumption to do that. And I was like, guys, look, this is about protecting our people. And, I'm happy to find the text of what I said, and I'm happy to share that at some point. Obviously not now. And of course, after that, he told me, he was just granting me a friendly privilege. Nothing was going to come out of that. They were going to pass quickly, which they did. But the thing is that in doing that negotiation, only one member of my governing council went along with the idea. In 2013, after negotiating with my governing council for over 1 year, we agreed in Lagos in June 2013 to meet with representatives of Nigeria's sexual minority advocacy communities, SOGIE community essentially. And so they came to meet us at the meeting of the Governing Council in Lagos. And that negotiation took over 15 months to come to fruition. That is, members of the Governing Council of the National Human Rights Commission said, no, we will not meet with these people. I'll put it in quotes, we will not meet with these people. And so the first challenge was persuading my Governing Council that it was important. Now, we had everything reflected in the Governing Council, from mullahs to evangelicals, and everything in between. And essentially, this was a dialogue with religious points, faith-based points of view. Pretty much all of us were lawyers, by the way, but they defaulted to faith. That's the first thing that you've got to deal with here. When eventually the representatives came into the chamber where we were meeting, one of my members went into prayer and started casting and binding. Anybody who is Nigerian here, when I say, or West Africa, when I say casting and binding, would understand what I meant, what I'm talking about. Another member brought out his prayer beads because he was a Muslim and started chanting prayers. I allowed them to finish and we had our meeting, which was actually very fruitful. The meeting went on for over 2 hours. And what it did help us do was establish dialogue with the community, and then also show staff of the commission, because that for me was the limited objective, get staff of the commission to begin to have contact with people in the community, in the advocacy community involved. So we established that, and that began to happen. By the time I left in 2015, the Human Rights Institute of the Commission had started work on documentation. I think some of that went into the, I know that some of that went into the report of the Human Rights Commission, the last report that my Governing Council did. I cannot say for sure that I know very much what has transpired since then, but this is a shorter version of what could be a much longer story.
Thank you for that, Professor Chidi. I see there are no further questions on the chat. So what I will do right now, before we hand over to closing remarks, I will head over to Taruna in order for us to show the animation. And then after the animation, I'll come back to just give us an opportunity for Ayo to make some closing remarks.
Across Africa, many people continue to experience violence and discrimination on the basis of their real or perceived sexual orientation or gender identities and expression. SOGIE. People may identify in many ways: lesbian, gay, bisexual, transgender, queer, intersex, or non-binary, while others do not identify this way, but are also persecuted because of how they are perceived. Regardless of how a person identifies or expresses their identity, and regardless of who they love or have sex with, they are entitled to the full protection of all human rights without any discrimination. Nobody should experience violence and discrimination on the basis of their sexual orientation or gender identity. The enjoyment of human rights in Africa is guaranteed by a range of global and regional treaties and instruments, including the African Charter on Human and People's Rights, which guarantees a right for all people to equality and freedom from discrimination of any kind. Though the African Charter does not explicitly mention sexual orientation and gender identity, international law conventions broadly prohibit discrimination on this basis. the African Commission on Human and People's Rights has issued Resolution 275, aimed at protecting LGBT plus persons against violence and other human rights violations. The resolution makes it clear that the African Charter protects everyone, regardless of sexual orientation and gender identity, and it strongly condemns violence or any other form of discrimination, abuse, or persecution based on sexual orientation and gender identity. Tragically common examples of such violence and discrimination in Africa include murder, rape, assault, arbitrary imprisonment and targeting of LGBT persons and their allies by law enforcement authorities or third parties. Even in states where LGBT plus identities and expressions have been decriminalized, there is often a persistence of negative social attitudes that lead to violence and discrimination. The International Commission of Jurists calls on governments across Africa to 1. Enact and implement laws prohibiting and punishing all forms of violence targeting persons based on SOGIE, and establish legal procedures responsive to the needs of victims. 2. Enact legislation aimed at prohibiting and preventing all forms of discrimination based on SOGIE in the enjoyment of human rights and ensuring redress for victims. 3. Ensure proper investigation and diligent prosecution of perpetrators of violence based on SOGIE. 4. Undertake campaigns to eradicate negative social attitudes and educate and sensitize law enforcement and judicial authorities to ensure respect for the human rights of LGBT plus persons. 5. Repeal laws that criminalize LGBT plus identities.
Thank you so much. That was a wonderful, wonderful animation. And now we'll hand over for closing remarks, Dr. Aya from the International Commission of Jurists. The floor is yours.
Thank you very much. And it's been a very, very educating day. And I am so glad that we've been able to have this event bringing everybody together so far to discuss and to look at what the situation is in terms of SOGIE adjudication and litigation in Africa. And, starting with the opening address that was delivered on behalf of Mr. Gebasebiogo by Laura Rudikori, we can see that more or less there seems to be a dualized scenario in Africa where we have on one hand a set of judicial developments that are progressive in nature and where the judicial reasoning is focused on rational elements of human rights in a democratic society. Then on the other hand, it seems we have a different system where not just the judiciary now, but the entire legal system seems to be retreating backwards into the colonial understanding of social order and this hierarchical and strictly heteronormative version of what a society should look like through the introduction of new laws, through the rejection of claims, human rights claims based on SOGIE. And for those of us who are concerned by all of these issues, I think what is clear is that there is an opportunity for navigating this divide, because at the end of the day, we share this common boundaries, this common environment, this Africa. And I think there's an opportunity for an exchange of ideas and exchange of values, especially in order to encourage those who are less inclined towards progressive ideas to consider and to work towards that kind of progressive society that is democratic and that ensures that the human rights of everyone in society is well protected. And it is clear to me again from the conversations on the panel that we've had, and my thanks to Dr. Udochigudu, Professor Chidi Odinkalu, and Monika Tabengwa for their various discourses and how they've been able to articulate the fact that it's not just about the judiciary alone, even though the judiciary is your primary concern is, but also about the wider systems of power dynamics in the society, the ways in which democratic values are either celebrated or rejected, and the ways in which there is adequate knowledge and understanding within institutions of the state on SOGIE issues, LGBTIQ+ issues. And I believe that having this kind of conversations is one of the steps towards the enlightenment of our judicial systems. And I believe also that if we are able to maintain the, so to say, the energy that we address or we come to these events with and take it back and say, look, what are the ways in which we can then work with the people who are responsible for making policy, who are responsible for shaping institutions in our society, there may be some measure of progress can come out from all of this. But nevertheless, I want to thank everyone who has been here since the beginning of the of this session. The next session will be focusing on ESCR issues, and it will also be starting with an opening address and a panel conversation. And I invite all of you to please log back in later and also join that session before we continue tomorrow with the other sessions. Thank you very much for your time, and I look forward to seeing more of you all later on. I'll now hand back over to our facilitators. Thank you.
Thank you so much, Ayo, for the closing remarks. I think it's been a really fantastic morning of really a broad spectrum of discussion. You know, we heard the keynote address, which was speaking about a stench march to progress, the idea of reflecting on recent jurisprudence in SOGIE rights development and adjudication in Africa. We heard the case about Semenya, we heard about Jade September, we heard about cases that range from Botswana as well as Kenya. Then we had a really meaty conversation about creating the judiciary in Africa, navigating differences and diversity under the doctrine of precedence. And that was also wonderful. Then we were also given a treat of the animation. And finally, we were able to hear some closing remarks from Ayo. Now we're going to take a break, and we'll be back here at 13:05 minutes. So we'll be here at 1:05 to continue with our next session, which will be our session on the economic, social, and cultural rights. And we hope you will join us then. In the meantime, you can either stay on the platform or leave the platform and come back later. But what you're able to do is as well, keep your videos off and keep your sound on mute so that when we do come back indeed, that you're able to join us again. Thank you, everyone. Have a wonderful lunch if you're going to have a lunch, or a wonderful break if you're just deciding to take a break. Thank you, everyone.